Welcome everyone to this session on Brexit and how data protection law has changed since 11 p.m. on the 31st of December 2020. My name's Eleanor and I'm a lawyer at Fieldfisher in London. So this is the second year of our Get Data Protection Fit series. If you've been through the whole series, you are very data protection fit, I imagine. So this really is an opportunity over the next year to focus on particular areas, to give you some updates and to allow you to address some of your burning questions to the team. So the sessions for this year are as follows. After this session on Brexit, we're going to be looking at data protection by design and by default. Then we're going to have some legal updates for the first quarter. Then we're going to look at the Digital Services Act and other relevant legislation. We're going to respond to your subscriber Q&A, and I'll tell you how to pose your questions at the end of this session. We're going to have legal updates in the second quarter. We're going to talk about the age-appropriate design code and when to update or refresh your data protection training. Then we'll also have updates for the third quarter. We'll respond again to your questions. AI and ethics will follow, and finally we'll have updates for the fourth quarter of 2021. So the structure of this session is that I'm going to be looking at what happened at the end of the transition period. Firstly, at the international level and the international landscape, and secondly, what happened domestically to data protection law in the UK. So in terms of the learning outcomes, by the end of the session, you should be better able to explain what the EU-UK Trade and Cooperation Agreement said about data flows, the changes that happened to UK law at 11 p.m. on the 31st of December 2020, what that means in practice in the data protection law context, and what the future holds. So firstly, what happened at the international level at the end of the year? And you see I've got the pictures of Christmas decorations because, as I'm sure you know, on Christmas Eve, the UK and the EU agreed the Trade and Cooperation Agreement, which is going to regulate the future relationship in terms of trade and security and other matters, including data, going forward. So what are the main takeaways in terms of the Trade and Cooperation Agreement in the context of data protection? Well, there are four main points that I want you to be aware of. Firstly, the bridging mechanism. So this is a mechanism in the Trade and Cooperation Agreement which allows the free flow of data to continue from the EEA to the UK for up to 6 months. And the reason for that is that the Trade and Cooperation Agreement envisages an EU adequacy decision for the UK being conferred in that 6-month period. So adequacy for the UK isn't fully guaranteed in the agreement, but the agreement does pave the way, it does foresee, it does envisage an EU adequacy decision in favour of the UK. The third of the four main takeaways is that the Trade and Cooperation Agreement contains provisions which provide greater stability for EU-UK data flows. Now, what do we mean by that? Well, the agreement contains something called a Partnership Council, which makes decisions about how the agreement is implemented and decides matters which are in contention between the parties. And one of those could be adequacy, and in particular, any loss of adequacy by the UK. And there are some very specific provisions in the context of law enforcement, but less specific provisions in the context of other types of processing. But nonetheless, there is scope within the agreement for the Partnership Council to provide political solutions if the UK was to lose its EU adequacy decisions. And what that means really is that, as opposed to the situation we had with Safe Harbour and Privacy Shield, two adequacy decisions which were struck down by the Court of Justice, if that were to happen, or if that were to be on the cards, then the Partnership Council, under the Trade and Cooperation Agreement, can step in and provide a political solution. And that was something that was missing from those previous adequacy decisions which were declared invalid. Safe Harbour and Privacy Shield. So I think it's arguable that the Trade and Cooperation Agreement does provide greater stability for EU-UK data transfers, data flows, than the standard, if I can call it that, adequacy decision. So that's the third takeaway. And the fourth takeaway isn't actually in the Trade and Cooperation Agreement. It's set out actually in UK domestic law, but it sets out in that legislation, in that domestic legislation, that UK to EU data flows can continue as normal. So no special mechanisms will need to be put in place. There's a free flow of data after the end of the transition period for data flows from the UK to the EU. So now I'm going to look in a little bit more detail at what happened at 11 p.m. on the 31st of December 2020. And I've got a picture here of Whitehall where ministers make decisions. Ministers have decided, some time ago now, but they decided that it was very important not to simply allow EU law, which was in the UK's legal system, a huge amount of law, to simply disappear at the end of the transition period. And the end of the transition period, of course, was 11 p.m. on the 31st of December 2020. So at that moment, EU law stopped applying in the UK. And had we done nothing further, then that law would have simply disappeared. But that would have been problematic. We wouldn't have had law in several areas of the economy, including data protection law. So a decision was taken to fix that problem by saving EU law at 11 p.m. on the 31st of December and turning it into UK domestic law. So how did we save EU law and turn it into domestic law? Well, we used some legislation called the European Union Withdrawal Act 2018, and that was its absolutely central function, taking EU law as it applied the moment the transition period ended and turning it into domestic law. And it did that in slightly different ways. So where you have direct EU law, like the GDPR, a regulation that applies directly in the law of the member states, then what we did was that we used the mechanism in the European Union Withdrawal Act 2018 across the board, but also in relation to the GDPR, to save it. If we hadn't done that, it would have simply disappeared. So the GDPR became national law and was turned into the UK GDPR. And the UK GDPR, along with other direct EU legislation, falls within a new category of domestic law in the UK's legal system called retained EU law. Another aspect of retained EU law is domestic law, which implemented EU obligations. And I've given a couple of examples that will be familiar to you. So the Data Protection Act 2018, for example, is domestic law, but it sits alongside the GDPR. It creates exceptions or conditions which the GDPR requires in order to work properly, and that's also saved under the EU Withdrawal Act. And so are regulations which were made under domestic law, which gave powers to ministers to implement EU law. So an example is the Privacy and Electronic Communications EC Directive Regulations 2003. They are also saved and fall within the category, the same category as the GDPR, of retained EU law. So how do you interpret retained EU law? Well, the starting point is that you interpret it as you did before. And that gives certainty and continuity in terms of what that legislation means in our legal system and provides that clarity to individuals, businesses, and government about what the law is after the transition period has ended. So the starting point in terms of how you interpret retained EU law is that you interpret it as you did before. So if you wanted to look at the recitals to the legislation to understand it better, then those are still available and you can use those for your interpretation of what it means. And also the case law which interprets that legislation has also been saved, and that's called retained case law. So you use retained case law to interpret retained EU law and to essentially give it the same meaning as it had before the end of the transition period. So what does retained case law comprise? Well, it comprises the retained EU case law of the Court of Justice of the European Union. So, for example, the Schrems II case, which we're all very familiar with, has been saved into UK domestic law as retained EU case law. Retained case law also comprises domestic case law, which interprets retained EU law. So an example is the case of Bridges, which was to do with facial recognition and the lawfulness of using that. And the GDPR, and in particular data protection impact assessments, were looked at by the domestic courts in that case. And so that case is also saved and can be used to interpret retained EU law, so the UK GDPR and the Data Protection Act 2018. Now, it is worth being aware that this saving of the GDPR and turning it into the UK GDPR is not quite as simple as all that, because EU law wouldn't just work unamended in our domestic legal system, because, for example, the GDPR contains references to the European Commission conferring adequacy decisions. That's just one place where we've got an EU reference that needs to change in order for the GDPR to work properly as a UK version of that legislation. So I've got here the name of two EU exit regulations that make amendments to the GDPR when it becomes the UK GDPR, but also to the Data Protection Act 2018 and the e-privacy regulations in order to make them work properly as domestic law. And together, these two regulations are known as the DPEC regulations. So they make the sort of changes as set out in the slide, changing references to the European Commission to, for example, the Secretary of State. So under our new regime, it'll be the Secretary of State who will confer adequacy on third countries, UK adequacy this is, rather than the European Commission, which only has jurisdiction, of course, in terms of the EU and the EU member states. So that's just an example of one of the many changes which are made under these EU exit regulations, and it's really important to get to grips with those changes in your area of practice and to work out what they mean for you. So there are 7 changes brought about by the coming into force of the UK GDPR and the amending of it by those EU exit regulations that I want to make you aware of, because these matter from a compliance perspective. So firstly, the terms and conditions, the policies and procedures that you have in place are likely to reflect the fact that the UK was an EU member state. So where there are references to the member state, for example, or the territory of the member states, that may well still include the UK, and that's not going to work anymore, of course, because the UK is no longer an EU member state and no longer subject to the EU treaties, and the GDPR does not apply to the UK. In fact, of course, as we've talked about, we have the UK GDPR. So you may need to update your terms and conditions, your policies and procedures to reflect those changes. Secondly, in the area of international transfers, because of the bridging mechanism, the UK can't make any changes to its international transfers mechanisms under the UK GDPR, but those may be coming potentially down the track. So it may be, for example, that the UK publishes its own version of the standard contractual clauses, which are slightly different from the EU's version. So those changes potentially will matter to data protection practitioners. Both the EU GDPR and the UK GDPR have extraterritorial scope, and so it may be that UK companies are caught by the extraterritorial scope of the EU GDPR, and EU companies are caught by the extraterritorial scope of the UK GDPR. So that's something to be aware of as well. And that's relevant to the next point, which is the appointment of a representative in the EU or UK territory if you're caught by those extraterritorial scope provisions. Another change to be aware of is that the regulatory cooperation mechanisms in the EU GDPR, such as the one-stop shop, do not apply in the UK GDPR, and that brings about some complexity. So where before you were only dealing with one lead authority, that may no longer be the case. Another point is that although we've saved Court of Justice case law as retained case law, retained EU case law, the judgments of the Court of Justice of the European Union, which are handed down after the end of the transition period, are not binding on UK domestic courts. So there's a dividing line between what came before the end of the transition period, where the starting point is that the Court of Justice case law is binding, like the Schrems II case, but after the end of the transition period, if there were to be a new important case in the area of data protection from the Court of Justice, it would not automatically bind the UK's domestic courts. So that's something to be aware of, a divergence potentially between the case law in the UK and the case law in the EU. And there's a question mark as well about EDPB guidance handed down after the end of the transition period. What status does that have? So I'll discuss all of these in a little bit more detail in a moment. So let's look in a bit more detail at international transfers. So where are we at this very moment? Well, as I explained earlier, EEA to UK transfers can continue as normal whilst this adequacy bridge applies the next 6 months. And the idea is that the EU is going to confer adequacy on the UK during those 6 months. I think there's very little doubt that it is in fact going to happen. Next, UK to EEA transfers can continue as before under the UK GDPR. And it's worth being aware that the international transfers mechanisms which the EU has have been adopted essentially by the UK in the UK GDPR. So where the EU has conferred adequacy decisions on countries like Japan, Uruguay, Argentina, New Zealand and others, those adequacy decisions can still be relied upon by UK companies transferring data to third countries. So that is something which hasn't really changed. UK companies transferring data to third countries can also rely on the EU's current standard contractual clauses. And that's the case both for new transfers, so transfers which are happening for the first time, but also existing transfers. So the EU standard contractual clauses are still a valid transfer mechanism for transfers out of the UK to third countries. And in terms of BCRs, those still exist as well, but if your BCR is an EU BCR, let's say you had a lead supervisory authority in the EU, then you need to notify the ICO if you want to convert that BCR to a UK BCR. If you already have a UK BCR, because the lead authority was the ICO, then you need to make some updates to your BCR. But that mechanism is still in place. And the exemptions in Chapter 5 of the GDPR still apply in the UK GDPR. So you may, for example, be able to rely on consent or another derogation. But obviously the narrowness, if I can put it that way, of those exemptions still applies. So they really can only be used in circumstances where you're not making regular transfers of data. So what's happening with international transfers in the future, and why is this an area that you need to look out for and consider in terms of compliance? Well, we've got the EU adequacy decision for the UK coming. As I say, I don't think that's going to be problematic, but worth keeping your eye on where we are with that. The ICA's guidance says to consider putting in place alternative transfer mechanisms. Obviously, that's a very cautious approach, but in my view, I think there's very little doubt that the UK is going to get adequacy. So you do really need to think about whether you've got the resource to plan for something which is relatively unlikely to happen. Next, I think that international transfers is going to be a very interesting area from the point of view of UK policy. You may be aware of the National Data Strategy, which sets out that the UK wants to be a world leader in data. It wants to be the champion of the free flow of data and of international transfers. So I think we can see from the National Data Strategy that the idea is going to be that the UK really forges relationships with other countries, both in terms of trade, but also in terms of data flows. And I think we can expect to see that the UK will be conferring adequacy on third countries that meet that test in order to allow free flow of data and for those economies to be closer and for there to be more business between the UK and those countries. That, in a sense, is part of the post-transition period vision for the UK economy, forging those relationships with third countries. And I talked about the potential for new UK standard contractual clauses as well. So that's something to watch out for. I talked as well about the extraterritorial scope provisions and the possibility of needing a representative. So just to unpack that in a little bit more detail, of course, it may be that EU companies are caught by the UK GDPR either because they have a branch or an office or an establishment in the UK. So this is Article 3.1 now of the UK GDPR that they would be caught by. And so they are therefore subject to the UK GDPR as well, of course, as being subject to the EU GDPR. Or they might be caught by the extraterritorial scope provisions because those EU companies are selling goods or services into the UK or monitoring the behaviour of data subjects in the UK. So a representative may be required in those circumstances. And conversely, UK companies may also be caught by the EU GDPR. So caught by both the UK GDPR, where they're established, of course, but the EU GDPR as well may apply to them because they have a branch or office or establishment in the EU. So that's Article 3.1 of the EU GDPR, or they may be caught by Article 3.2 of the EU GDPR, the extraterritorial scope provisions, because they're selling goods and services into the EU or monitoring the behaviour of data subjects in the EU. So a representative in the EU may be required. Now, the other matter which is worth being aware of is that the regulatory cooperation mechanisms are no longer part of the UK's domestic data protection regime because they're removed from the UK GDPR. So prior to this moment, when the UK was regulated by the EU GDPR, we had the concept of a lead authority. So you had one supervisory authority that you could deal with if you undertook cross-border processing. So, for example, if you had establishments in several EU member states, you could have one lead authority who would take the lead for breaches and enforcement action. So, in terms of the lack of regulatory cooperation and the application of the one-stop shop for UK businesses, if you're a UK business but you're also established in an EEA member state, then you won't benefit from the one-stop shop from the lead supervisory authority. So this won't be cross-border processing, and you could have action taken against you by both the ICO and the EEA authority. But also, if you're established in the UK and you have two or more establishments in an EEA member state, then the cross-border processing, so the application of the one-stop shop, will only be there in terms of the EEA states. So you could have the EEA state, which has the larger customer base, being the lead authority, so the supervisory authority in that EEA state would be the lead, and you could be subject to action by the ICO and the lead supervisory authority. If you're caught by the extraterritorial provisions of the EU GDPR, so you don't have an establishment in the EEA, but you offer goods and services to EEA data subjects, then again, you won't be able to use the one-stop shop. You won't have a lead supervisory authority, so you could have enforcement action taken against you by all the supervisory authorities where data subjects have been affected. So in this example here that's illustrated, you could have perhaps the UK and France and Spain, all three supervisory authorities taking action against you. Now, another aspect that I mentioned, practical implications, no continuing alignment with Court of Justice case law. So it's really important here to distinguish between the case law that we've saved into domestic law, that's the case law from the Court of Justice from before the end of the transition period, and what happens after the end of the transition period. So if a case is handed down after the end of the transition period, then the UK's domestic courts won't automatically follow it. And so that is potentially going to be an issue for companies who are caught by both regimes, because it may be that they start to be interpreted in quite different ways. So that's something to watch out for in the future. But actually, it is a little bit more complex than that in reality, even in relation to past Court of Justice case law. Because if we have new regimes, for example, new standard contractual clauses, it may be that the government decides, takes a policy decision that previous Court of Justice case law should not apply to those new regimes. So it may be that if we had new standard contractual clauses, the Schrems II decision wouldn't apply to those. So that might sweep away some of the past Court of Justice case law. And another way in which past Court of Justice case law can be swept away is that the government has given powers to senior courts in the UK to depart from Court of Justice case law where they consider it right to do so. Now, we don't know when that power might be used, or indeed if it will be used, because it will create quite a lot of legal uncertainty. But it may be that the Court of Justice's case law is actually swept away by the domestic court, so the past case law. So although the starting point is that case law is binding, in reality, we may find that it is swept away and relatively In terms of the status of EDPB guidance, last time I looked at the ICA website, which was quite recently, it wasn't entirely clear what status that's going to have. So the ICA has said that its guidance is still relevant after the end of the transition period, and that guidance does link through to EDPB guidance. So there may be an implication that the ICA is intending for past EDPB guidance still to be relevant in the UK, but other regulators have come out very explicitly and explained what their policy is in relation to past guidance, and also compared with guidance which is handed down after the end of the transition period. So it may be that the ICO decides from a policy perspective not to follow EDPB guidance, which is currently in draft, and that includes the guidance on how to implement Schrems 2, but also the guidance on controller and processor. And the reason that it's possible that the ICO might not follow those to the letter is that they do impose really heavy compliance burdens on controllers and processors. So, for example, doing a mini adequacy assessment, which is a difficult task. That doesn't really fit with the national data strategy and the idea that we should have a regime that isn't too burdensome for the average company. So I think this is an area where the regulator will be looking quite carefully and considering whether this guidance actually is something that fits with the way in which data protection policy and strategy is being thought about in the UK. So just to recap, I think the changes that really matter to you and the ones you should look out for are updating your terms and conditions, international transfers, where the mechanisms are more or less the same at the moment, but we may see some changes relatively soon. The extraterritorial scope provisions in the EU GDPR and the UK GDPR may be relevant. You may need to appoint a representative if you're caught by those. The cooperation mechanisms in the one-stop shop don't apply in the UK GDPR, so you may find yourself without a lead authority and having to answer for your actions in a cross-border processing situation, both to ICO and to one or more regulators in the EU. Post-transition period Court of Justice case law won't be binding on the UK, so we may find divergence in terms of case law as well, and there's also a question mark, of course, about past Court of Justice case law. To what extent are we really going to be looking to that in the future, or will new regimes or decisions from the domestic courts sweep that case law away? And the uncertainty about the status about EDPB guidance, potentially post-transition period guidance not having the same status in the UK. So what does the future look like for UK data protection law? I think the main question is, are we going to be following quite closely what the EU does, or are we going to be moving a little bit in our own direction? And if we are, it is a bit of a game of chess, because the further away we move from the EU, the more likely it is that any adequacy decision in favour of the UK is challenged successfully, although of course we do have those mechanisms in the Partnership Council to give a bit more stability to that. But I think there is an awful lot to consider and some question marks over what the future looks like for UK data protection law. So hopefully now you are better able to explain to someone in your company what the EU UK Trade and Cooperation Agreement said about data flows, the changes that happened to UK law at 11 p.m. on the 31st of December 2020, and what that means in practice for domestic data protection law in the UK, but also how the EU GDPR might apply to UK companies and vice versa, and also a bit of a sense of what the future holds. So I said at the beginning that we were going to have a subscriber Q&A session. So do send us your questions and we will try to respond to as many as we can in our May YouTube session. We've set out the email address that you should send the question to, and please make sure that you mark the subject line as set out on the slide and your questions will reach us. Here are my contact details. Do get in touch if you have any questions about Brexit and data protection, and we will be back next month with our session on data protection by design and by default. Thank you for listening.